As an insurance litigator, one of the most common difficulties I see is contractors not understanding and therefore not fulfilling their contractual obligations. The standout areas for me are contractual indemnities and obligations to insure. Both of these clauses are intended to shift risk from one party to another, usually from the principal to the contractor. In the case of a contractual indemnity, one party, usually the contractor, agrees to take on the risk or liability of another party, usually the principal. For instance, if you take a carpentry company, it enters into a contract to undertake work for a building company. As part of that contract, the carpenter agrees to take on any liability of the builder in relation to injury to its own workers while on the worksite. Assume now that one of the carpenter's workers is in fact injured while on site, and that injury occurs because the builder fails to put in place safe scaffolding to keep the worksite safe. Obviously, the builder is at least partly liable for that injury. However, because the carpenter has agreed to indemnify the builder, the carpenter, and perhaps its insurer, will be completely liable for the claim. The risk has shifted from the principal to the contractor. The other difficulty with this scenario is the liability that has shifted from the principal to the contractor may not in fact be covered by the contractor's insurance. This leaves the contractor with an uninsured liability for damages, which could reach into the hundreds of thousands of dollars. The second clause I see contractors having difficulty with is obligations to insure. These types of clauses require a contractor to take out insurance for the benefit of the principal. Taking out insurance to cover another party is often expensive, increasing the contractor's cost of doing business. If a contractor doesn't take out insurance, the principal may sue them for breach of contract. For instance, if the principal finds themselves in a situation where they would like to make a claim under the policy, but they're unable to do so, they'll sue the contractor for breach of contract. The measure of damages for that breach of contract will be the value of the claim that the principal could have made on the contract of insurance. So for instance, if the principal could have made a claim for $100,000, instead they'll sue the contractor for $100,000. So you can see that both of these types of clauses can spell big financial trouble for a contractor if they're not properly understood and fulfilled. There are things that we can help you do to avoid this type of situation. By contacting us during the negotiation phase of the contract, we can help you to properly understand the clauses and, in some cases, negotiate more favourable terms. For instance, we can negotiate a contractual indemnity which is not as broad in scope, or perhaps an obligation to insure which will not be as costly for your business. We can propose amendments to the draft and help you to negotiate with the principal contractor. Once you've signed the contract, we can help you understand all of the clauses and ensure you fulfil your obligations under the contract. We understand that contract negotiations move quickly, and we read and draft contracts every day. So we'll provide our advice to you on a timely basis so that you can keep your negotiations moving and get back to doing your job with peace of mind. Our insurance litigators work with other teams within Hopgood Gannam specialising in energy, resources and projects, and construction. In addition, our insurance team has a particular focus on labour hire employers and care workers, and has worked with a number of labour hire companies to negotiate more favourable terms, particularly in the mining industry. Whilst your company might enter into contracts frequently, it's important that each contract be properly reviewed. Sometimes clauses appear similar, but may operate differently in different circumstances. We can provide you with timely advice about whether the terms of each particular contract will provide the right protection for your business.